Good evening, everybody. TCA, in collaboration with Snehastam, along with Mantra Law Office, is presenting this webinar today. The purpose of this call is to provide latest immigration updates from October Visa Bulletin on EB1, EB2, and EB3 green card date updates, and also any questions on downgrade from EB2 to EB3. Telugu Cultural Association was founded in 1976 to preserve and promote Telugu language, literature, culture, and heritage, and also work for the unity of all the Telugu people and bring them together under one umbrella. And also collaborate with other non-profit groups or communities for social and charitable causes. Snehastam is a service-oriented non-profit organization working on a motto of no one should be alone together. No one should be alone. Together we can make a difference. Snehastam cares for vulnerable people in the community like homeless people, underprivileged children, patients, and domestic violence victims. During the COVID times, they have been assisting the helpless people in number of ways. Uma Mantravadi garu is a well-known immigration attorney with over 25 years of experience serving large companies, small businesses, non-profit organizations, and individuals, spanning nearly every industry from healthcare, scientific research, non-profit service, and academic institutions to finance and technology firms. Also devoted to aliens of extraordinary ability, she has extensive experience serving institutional and individual clients in the arts, entertainment, and design professions, including the fine arts, graphic and web design, performing arts, culinary arts, architecture, interior design, industrial and fashion design. She advises employers on screening, hiring, and I-9 practices, as well as aspects of work visas and green card sponsorship for work development and retention. She advises and helps individuals to obtain the right visas, permanent resident green card, and US citizenship. She helps to plan appropriate visa strategies for transitions from student to professional, for job and career changes, to unite family members, and to overcome ground of ineligibility or other obstacles to a visa, green card, or citizenship. So now Uma Mantravadi garu will start the seminar. Welcome, Uma garu. I'll present the presentation.
Yeah, thank you so much, Sirisha, Geeta Garu, the entire board and executive members of TCA. A very, very special thanks to Devi Garu, Indira, Madhuri, and entire board members of Sneha Hastam. But for these two organizations, this webinar would not have been possible. And believe me, they're all working late hours and making sure that we present a webinar to the community so that this would be of great help to all those people who are currently facing immense confusions because of this October 2020 visa bulletin. So once again, I want to thank Devi Garu, Geeta Garu, Sirisha Kineni, Indira, and the entire team. They all need a big round of applause, and I want you all to thank them at the end of it. So let's start with EB2 to EB3 India for India and the downgrade. Let me also, I know Sirisha gave me a wonderful introduction, but let me also say she missed out saying some of the things she may not have known also, that I'm just an immigrant just like you. I also got my green card based under EB2 way back. Back in those days, we did not have such huge backlogs. So those were the good days when we could get a green card based on EB2 or EB3 within a few years. We didn't have to wait so long. But however, I did go through this process. So I fully understand the pain and suffering that each of you go through, including your spouses, for all the tension that you all face. Coming back to the October 2020 visa bulletin, all of you know that we just received it last week. There has been history that usually the visa bulletin is released for every month or the following month by the 15th of the month, no later than that. We've seen the history showing us that, but particularly the October visa bulletin was not released to us until the 25th or 26th of September, which is kind of a little questionable why they waited so long to do that. So having said that, even though they released it late, we are lucky we got it. And we're trying to see how a lot of people who are in the EB2 want to go to the EB3. Now, question is, why do people want to downgrade? Why does somebody wants to downgrade? We can go to the next slides. Why is everybody in this mad rush of wanting to downgrade? And what is an EB2 to EB3 downgrade? Uh, I've seen this in my years of practice that very few times the visa bulletin has moved up so much. And I can tell you the instances when it happened way back in 1997, and the second time it happened was in 2001. Again, this happened due to a mistake by the Department of State when they published it in 2010, sorry, 7, and the last one was in 2012. So when we have these opportunities, where the visa bulletin is shown a great upward movement either in the EB2 or EB3 categories, and people avail the opportunity and try to file in one of the preference categories, provided they qualify into that category. So this happens when individuals who have an EB2 priority date that is not either current under the dates of filing in EB2, but it is current under the dates of filing in the EB3 category, then they can actually downgrade their applications from an EB2 to EB3 and then file for an adjustment of status for themselves and also their family members. So this is what is an EB2 to EB3 downgrade. Now, is this done consistently? Uh, it can be whenever you find that the visa bulletin, and let me explain, the visa bulletin has two charts. One is known as the final action date, one is known as the date of filing. Now, these are two separate dates, and sometimes these dates can be quite advanced. And when this is published by the Department of State, the USCIS is the one who makes the decision whether to accept the date of filing or they're going to go with the final action date. Now, luckily, when this bulletin was issued, there was there was some turmoil even in the beginning. The USCIS came and said, no, we're not going with the date of filing, we're going with the final action date. Then they came back and said it's going to be the date of filing. And they went back and forth on that particular day. And finally, they did announce that they are accepting applications with the date of filing and not the final action date. So because USCIS has given us that privilege, now many people like you are able to downgrade your EB2 to an EB3 and then actually file the application. So we'll go to the next slide. And how does this work? How does one file from an EB2 to an EB3? Basically, the process, it's a step-by-step process, and I put it down as much as I can in my presentation also. Assuming you're working for the same employer that sponsored your EB2, or assuming you're now working for an employer that is not your EB2 sponsor, you're now working for an H-1B employer and not no longer working for your employer who sponsored your perm and your I-140, you can still file the EB2 to EB3 downgrade if your previous employer or your current employer who's filed your EB2 or EB3 is willing to go forward with this downgrade. So the very first thing you all need to know is your employer has to be willing to do this. If your employer doesn't have the willingness to do this, you cannot file the I-140 package to the USCIS. So the first thing, your employer has to be willing. Now, let's say your employer was employer A, but you're working on an H-1B for employer B, and employer B is willing to do it. However, they have not done a perm and an I-140 and not ported it. So they cannot file this amended I-140 under the downgrade process. It is only the previous employer who sponsored you for the perm and the I-140, they can do that. And a green card process or the perm labor certification and the green card process under the EB2, EB3 is an offer of employment, meaning it's not an actual employment right now, it is an offer, which is the reason why even though you've left your employer, you can still continue with the applications provided the employer is willing to support you with this process. So how does the employer support you? Let's say employer A who filed your perm and I-140, it's approved as an EB2. I'm just giving an example. Let's say your date is August 2014. And right now the visa bulletin is showing as May 2015 as the dates of filing is May 2015. And if that is true under EB2, you may not be able to file it, but if you downgrade it and file it in a EB3, then you can definitely file it. Now, how does the employer file it? He has to file an amended I-140 reflecting very clearly that he is filing it as an amended petition to an EB3. He's downgrading it from an EB2 to an EB3. However, he is wanting to retain the same priority date, which I gave you as an example of August 2014. So he's going to retain that same priority date, and he is now going from an EB2 to EB3 for this employee and filing the I-140 package with an amended I-140, but he still has to prove that he has the employer still has to prove that they have the ability to pay the prevailing wages as per the ETA 9089, and that the beneficiary still meets the minimum requirements of this position, which is probably a master's degree under the EB2, or it is a bachelor's with a 5 years progressive experience. So both the employer and the employee have to meet the minimum requirements in the certified ETA 9089. So additionally, the employer has to prove that they have the ability to pay these wages. And how do they do that? They've got to resubmit their federal tax returns or financial records, or if it's a big company with 100 or more employees, their CFO can certify that they have the ability to pay this employee. So they'll have to give all of that to prove that this is the ability to pay this employee, even though the same I-140 petition has been approved previously by showing all the documentation by the employer and the employee that they meet the minimum requirements. They've got to go through this step one more time. And we'll go to the next slide. Can we go to the next? Yeah. And based on your EB2, and if you downgrade it to an EB3 and you look at the date of filing, and as per the date of filing, if you do qualify, you can downgrade it, file the I-140 petition, and you can concurrently file the I-485 for yourself as the principal applicant and your spouse or children as derivative applicants. You can file for the advance parole, you can file for the 765, all the documents that are required to be filed so that you can benefit for whatever you need to benefit from the 765 and the advance parole. So the employer clearly has to certify that this application is an amended I-140 along with downgrading it to an EB3. However, they are capturing the same priority date, be it August 2011 or August 2014 or 2013, whatever your date is, they clearly have to mention that in the letter along with the application. They also have to provide a copy of the approved perm labor certification. And I would also include the previous I-140 so that it clearly shows the priority date and that they had an approved EB2 uh, I-140 so that it can be clearly proved. So these are all the steps that one has to take when filing for the downgrade. And the big question that everybody asks me is, why should I downgrade? Why do I need to downgrade? What am I going to achieve by downgrading it? The biggest thing is we have been noticing as attorneys, and I'm sure most of you who keep up with the visa bulletin have been seeing that years ago, EB2 was progressing quite well. I would say probably 2007, 2008, 9, 10, all those years, you could see that EB2 was definitely progressing much better than EB3. Then in the last 5 to 6 years, we have noticed a trend where the EB3 has been advancing much more than the EB2. And there are two reasons I can see why it has done that. And as I mentioned right in the beginning, way back there were a lot of people who were in EB3, and when they saw that the EB2 line was moving quickly, it's just like being on a freeway and you're in lane 2 and you see lane 3 is moving faster. You have a tendency psychologically to jump to lane 3. And then now lane 3 is now clogged up because there are too many people who jumped into lane 3. So which is typically what has happened here. A lot of people who upgraded themselves from an EB3 to an EB2, they have gone into that line and that line got clogged up. And because of that, you've seen that the backlog has come into the EB2. Otherwise, traditionally, it was always that the EB2 was moving much faster than EB3. So why does somebody want to now downgrade it from an EB2 to an EB3 and go through this process is because we've noticed a trend wherein the EB3 looks much favorable as compared to the EB2. Now, many people will ask me this question much later, and I'm sure I will see questions from each of you saying that what happens 2 months from now, 3 months from now, if you notice that the EB2 is moving rampantly faster than EB3, can I go back to my EB2? Will my EB2 remain intact after I downgrade myself in this process? File the adjustment of status, what would happen to my EB2 petition? Your EB2 petition will remain intact even though you have downgraded yourself and filed an amended I-140 petition asking to be reclassified under the EB3 category. Your EB2 will still remain intact. So can you go back to do an interfiling? It is possible. However, there are a few glitches, and we'll talk about that when the Q&As come. I'm pretty sure there's going to be a lot of people asking that question. So what happens to your EB2? The EB2 remains intact. Nothing happens to it. It will remain as is. Now, if you think, hey, the EB2 line is definitely moving better, and I want to go back to EB2, I don't want to be in the EB3 line, you can interfile into the EB2 category. However, there are going to be some issues that have to be discussed, and I will get to that. So let's move on to the next slide, please. Now, a lot of people ask me, ma'am, if I file this I-140, I'm reclassifying myself from an EB2 to an EB3. My employer is willing to do this. I've got all the documentation. I have no problems. I meet the minimum requirements. My employer meets the minimum requirements. Now what happens? Can I file this as a premium processing? Because I want to make use of this premium processing. I don't want to sit with this I-140 for months and months and months. Whenever you're filing, refiling, and reusing a perm, a labor certification, which was previously used, meaning you use the original approved ETA 9089 when you filed your EB2. you had to use it in order to file the I-140. So when you have already used that, all you have is a copy that you have with your employer. So when you're using a copy and filing a reclassification from EB2 to EB3, you're only applying with a copy. So when there is a copy, the USCIS will not allow you to use the premium processing because they want the original ETA 9089, and they'll have to get that from the file where it was filed along with the EB2 application. So they'll have to get it from that file in order to process your reclassification as an EB3. So they will not allow a premium processing when you're initially filing. But as an attorney, most of us attorneys are advising that if you want to do a premium processing, I would give it at least a month or two, allowing the USCIS to actually get their hands on the original perm, certified perm that is being used in your EB2 filing. So once they get their hands on that and they can get a copy of that, or the original, I'm sorry, then you will be in a better position to now go and file a premium processing using the premium processing filing. So I wouldn't do it along with the downgrade. I would do it a little later once you get the receipt, and at least I would give them a month or two to allow them to access the original perm that has been certified. So I wouldn't do it immediately. And what can happen if you go for a premium with the downgrade process is they may kick back the package. Sometimes they kick back the entire package, and let's say that happens, and by the time your attorney or you receive it, it is past October 30th, and the November bulletin is not allowing you to file it. So then you lose the chance to get in your application. So to be on a safer side, I would highly recommend that you do not file it under a premium processing. Give them a month, give them 2 months at least, so that they can retrieve the original certified perm to bring it into this file so they can process it. Now, once that is done, and if you upgrade it to a premium processing, it'll be much easier on the officer to adjudicate it, approve it, so that you can move forward on this application. So this is how the whole process is. It is not a difficult process going down from an EB3 to EB2. I'm sorry, from an EB2 to an EB3. And most of you would meet the minimum requirements because you've already met the requirements when you filed your EB2, both you as an employee with your educational qualifications and your employer. So both of you would have met it. So I don't see too many hiccups when it comes to that. And as I said, your EB2 would remain intact, and you don't have to worry about the EB2 losing your place in the EB2 line. So that would remain intact. Let's go to the next slide, please. As I said, in general, the employer should be agreeable to do this process for you. That can be an existing employer with whom you're still working for the last 10 years, 12 years, and the employer should be agreeable to do this downgrade. Or it can be your previous employer who filed your EB2, and if they are willing to do it, you can go through this process. So if you need any help with this, please contact our office, because we are currently filing, I don't know how many, but there are hundreds and hundreds of applications that we are filing right now for many, many applicants, particularly because the employer's attorneys may take longer time. So we are jumping in and trying to help you all with the process. Coming back to, again, the dates are very, very important. Everyone needs to realize that you have only end of October to file this. And since October 30th falls, I believe, on a Friday, and so the last day for you all to file this application would be October 29th, meaning it has to be FedExed on 29th, so it is received by the USCIS on October 30th. I wouldn't take a chance of filing it in November because, as I said, it would be a decision of the USCIS if they are going to continue to accept the date of filing as opposed to the final action date. So we just have this 1 month window. Right now, we were already done with October 1st. So we're getting into October 2nd. So we are left with about 27 days to complete this process. But it should not be that difficult for y'all. If you have a good attorney who has the experience of doing this, I am sure they'll be able to help you with this. But however, if you are seeking help, I'll be glad to if you reach out to me. Let's go to the next slide. Again, you need to deter if you are departing after filing for the 485. Let me also warn you that all those who are filing for the adjustment of status, and you're also requesting an EAD as well as an advance parole, what you need to do is make sure that you receive your advance parole before you leave the country. Otherwise, they will consider that you've abandoned your I-485, be it yourself or your spouse. Both of you have to make sure that you get an advance parole before you leave the United States and go to India. You may be able to get a visa by getting a stamping at the US consulate. You may be able to come back, but that is not the issue. But if you leave the country without an advance parole, they will consider that you've abandoned your application. If we can move on to the next slide, please. And please work with your attorneys or with any attorney, or you can reach out to me to ensure that this process is done expeditiously and, of course, in an organized way so that you do not lose your space, your chance to file your application with the USCIS. Like I said, the last time I saw this was back in 2012, so it's been an 8-year period. And will we see this again in the month of November, December? I'm not sure. Wanted to also bring up another important aspect that most of you know, that the USCIS was supposed to have a hike in the filing fees starting October 2nd, which was tomorrow. However, just day before yesterday, there was a US district judge out of California who gave an injunction stopping the USCIS from hiking the fees because they felt the acting secretary who introduced the fee hike was not empowered to take this fee hike from the USCIS on behalf of the USCIS, because he was an acting secretary and he did not have the authority to empower this fee hike. So based on that, the judge has given an injunction, and the injunction is nationwide, so everybody can still follow the old fee, which all of you know how much it is. It is right now $1,225 for the adjustment of status application, and for filing the I-140, for the amended I-140 to downgrade it to an EB3, it is $700. And like I said, there is no premium processing that I would advise you to file along with the application. But if you wish to do it later, then there will be a fee for the premium processing. And the documents that you would need, everybody pretty much is aware of it, that you would need all your passport copies, your visas, your I-797s, your W-2s, your paychecks, any visa stamping that you may have for yourself, for your spouse, your marriage certificate, your children's birth certificate. Even if they are born here, even though they are not going to be getting a green card through your application, you still have to list them in your application, even those children who are born in the United States. So they would know what your family is, who you are, how many people, so that they would have a complete um, uh, rundown of yourself and your family, because later on you can't come and say, hey, I had a child, I forgot to mention this child, so they may not allow this child to be added if you forgot. So you need to make sure all the members of the family are listed in each of your 485s. In addition to that, today there was another announcement that came out, and I'm going to talk about that. There was a law or a bill that was passed in Congress, which is called the HR 8337, and in a move where both houses quickly approved this, where they're going to raise the premium processing fee up to $2,500. So a month from now, 2 months from now, when you will be upgrading your I-140, you would be paying the upgraded fee, which is, I believe, $2,500. And but the best part of it is the premium processing benefits are now available for all the EB2s, EB1, 2, and 3, any filings filed with it. And they're also expanding this premium processing for any H4 EADs, H4 change of status, and any EAD. So if you have an EAD that is pending, they said you could use the premium processing to get it quickly processed. But you are going to pay a hefty fee for that, and the date of when it is approved from is from October 1st, 2020, meaning it has gone into effect. This bill has gone into effect as of today, which is October 1st, 2020. Having said that, the USCIS has not published anything on its website, because they have to go through a policy change, what forms they have to give, how the fee is going to be paid, which categories are paying what amount of fee. But the maximum that they can charge is 2,500 for the premium processing. But I don't have a list of each category as of right now, but I will be getting it in the next 1 or 2 days. So I can give everything to y'all if y'all need that. But having said that, there is an injunction on the hike in fees. The other side, now we just get this HR 8337 that was passed. So it's kind of contradicting. One side there is a court injunction, one side there is a bill that was passed in Congress. And of course, the USCIS is definitely going to go and appeal the preliminary injunction that was given by the US District Court judge from California. So we are going to see that there will be a fee hike that may come back, or maybe the judge will give a permanent injunction. We don't know that. So that may happen rampantly, and you need to watch out if that happens. So whenever you send in your applications, you need to make sure you're paying the correct fee and not the old fee. So which is why you need to watch out for this updates every single day. So please make sure you talk to your attorneys, your employer's attorney, or somebody to make sure that you're paying the correct filing fee. Otherwise, your applications will be rejected and sent back. Just wanted to touch base on that. Can we go to the next slide, please? Once again, I need to emphasize that if you depart the United States prior to receiving your advance parole approval, the USCIS will definitely determine that you abandoned your application for adjustment of status, which is the I-485. And so you need to make sure that you get the form I-131 approved expeditiously. And like I said, with the HR Bill 8337, I'm not sure if they have included the I-131 for a premium processing. And if they have, then maybe you can make use of that and get it approved. Now, they have clearly also said that the premium processing is no longer going to be 15 days. What I read is the EAD would take at least 30 days, and there are some categories which are going to take up to 45 days. But let's look at it this way. It's a better to at least get it in 45 days rather than getting in 6 months or 8 months. So you may have a better shot at getting both your EAD and I-131 approved using this catch-all premium processing that the HR Bill 8337 is offering. So this is all I can talk about. I know there's going to be tons and tons of questions each one of you may have. And I will now give it back to Sirisha and Indira and all of you to, you know, to talk about any questions anybody has got, and we'll go through each of the questions.
Yeah, thank you, Uma garu. We have quite a few questions in chat session. We'll go through them first and then we'll open for other questions.
Sure.
Indira garu, you want to start?
Yeah, sure.
Yeah,
Thanks, Sirish
thank you.
garu. Thank you, Uma garu. So we'll
You're
start
welcome.
with the first question.
Uh-huh.
Say, could they revert back 2020 visa bulletin? So it's a prediction question.
No, they cannot. If they were to have reverted back, they would have done it one before October 1st. They cannot. And like I said, this happened back in 2012 and even 2007. I remember very well, I was on a vacation to Florida, and my staff sent me an email saying, hey, the visa bulletin was current for all categories, not just employment. It was current for every category, and it was a mistake. Somebody misprinted the visa bulletin in that form. But having said that, the State Department and the USCIS had to honor that. So similarly, now they have committed that they would go with the date of filing for the month of October. So I don't think there is any revert back on that. So you can be rest assured, you don't have to go to a parrot to get the future of this. For October, you're confirmed that this bulletin will continue. Now, what's going to happen in November? I don't know. I'm looking for the Aladdin's magic lamp. Once I get that, I'll tell you.
Okay. So the next question is, if EB2 is a self-petition under NIW with I-140 approved, then also can be downgrade to EB3?
Absolutely not. Whenever it's a NIW, you cannot downgrade it to, because it's a self-petition you filed under EB2. There is no employer, there is no perm, there is no I-140 that was filed by an employer. So you cannot downgrade an NIW to an EB3.
Okay. So the next question is, does SOC code has to be the same for porting?
For what? I'm sorry.
For porting, so like for EB2 to EB3 porting.
Yes, no, it will remain the same. They're not changing anything because they're just basically using the same approved firm. So the SOC code will continue to be the same. Your job title will be the same. Your job description will be the same. It is just that they are now downgrading it from an EB2 position to an EB3. So there is no change in the SOC code.
Okay, thank you. And the next question is, the priority date September 2010, EB2, and the first question is, current employer's green card processing is in the perm stage, and if the previous employer wants to file for I-485, should I work there? If yes, then when should I start working there and for how long? And does that need a H1 transfer?
First of all, as I mentioned right in the beginning, a perm labor certification and an EB2 or EB3 category is an offer of employment. So it is not an actual employment. So you do not have to work for that employer. So you had employer A, who was your previous employer, who filed your EB2, and now you've moved and you're working on an H1B for employer B. So you don't have to go back to work for employer A, even though they're willing to continue with the downgrade processing for you. Now, but if the employer insists, hey, you have to come work for me, otherwise I'm not going to do this for you, Now that's a whole different ball game between you and them. So, but if they are willing to do it, you don't have to go and work for the employer.
Okay, thank you, Magda. So next question is, how long is this time frame for filing will be open? Please give some information about SOC codes.
The SOC code will remain the same as I mentioned earlier. There's going to be no change in the SOC codes. So please don't confuse. This is not like an H1 where you're filing an H1 amendment or an extension where you're changing jobs and you're filing a different SOC code. Your job and your job title will remain the same as per the certified ETA. So you do not have to worry about the SOC code. When your employer is filing the amended I-140 petition, like I said, he will be attaching an approved perm and also a copy of the approved I-140, which was approved for the EB2. He or she would be filing it so they would see what are the documents that were submitted for the EB2 and the same is being used for the EB3. It's just that you are going down to the EB3 classification using the same perm and the I-140. Now coming back to your question, up to what date do you have to file this? You have until October 29th. That is your last day as per this visa bulletin. We don't know if the next bulletin would allow you to file and if the USCIS would accept as per the date of filing. So I would not be as optimistic that this can happen next month because it may not happen. So this is your chance, everyone. Luck is knocking on your door. You want to use this. This is your time. Make sure you take every advantage of it, provided your employer is willing to cooperate with you.
The next question is, are there any legal issues or complications for employer when they downgrade the petition from EB2 to EB3?
Absolutely not. All they need to know and prove is that there is a position available for the employee. They had a position available for this employee when they filed the EB2, and now they have a position available for this employee under the EB3 category. Secondly, as I said, when they file the amended I-140 petition to reclassify it as an EB3, they still have to show that they have the ability to pay this employee. And also the employee has to prove that they meet the minimum requirements as per the ETA certified perm labor certification. So there is no downsides to the employer, but as I said, this is a new I-140. The adjudicator is looking at it as a brand new application, even though the previous one was already approved. They don't go by that. They still adjudicate this as a brand new application, the I-140. They're going to look at the employees' educational qualifications, if there's any evaluation. For example, if the employee is going with a bachelor's and 5 years progressive experience, they're going to look if the bachelor's is equivalent to the US bachelor's, plus do they have the progressive 5 years experience? Do they meet those minimum requirements? So there is no downside to the employer.
Okay. How long does an employee need to stay with an employer before they can change the company after applying for concurrent filing of I-140 and 485? Does this clock start from the date of concurrent filing or after the I-140 gets approved?
Okay. Now, I'm assuming they're talking about the AC-21 portability. The AC-21 portability says if you have an I-485 that is pending for 180 days, you can port it to a new employer with a similar position, with a similar kind of business that they are in. Let's say, for example, if they filed for you as a software developer and you're porting it under AC-21 with a new employer, you have to be placed in a similar position with a similar kind of a business. For example, if I'm an attorney, I cannot be working as a pharmacist. So it has to be a similar position. I'll have to go and work as an attorney with my porting company. But it's 180 days from the date of your receipt, has nothing to do with your I-140, even though the I-140 could be pending.
Okay. The next question is, if I change from EB2 to EB3 and get my EAD, can a new employer file another perm and I-140 in EB2? Do I need to be in the same lower job role until I get my green card?
Your new employer can file a brand new perm and an I-140 in the EB2 position, provided you qualify for that. Again, they can continue with the perm application because it's only an offer of employment. And if you go to employer C, you were with B, now you're with the employer A, now you're with B, and you want to move to C. When you move to C, you will file an H1 with employer C, but employer B who started the perm and the I-140, if they wish to, they can continue and proceed with it. So you don't have to be employed there for them to continue. But if you wish to continue, you can do that.
Okay. And how are the yearly green card quota distributed across the three categories? How many green card visa is allocated to EB3 every year? What are the chances EB2 to EB3 downgrade 140 will be approved or rejected?
I'm going to pull up the chart and then give the numbers to you. I don't have it with me, but I'm going to pull it up and give the chart. But having said that, we look at the visa bulletin when we see the progress, whether it's EB1, EB2, EB3. For a long time, EB1 for India was always current. And we've never seen a retrogression in EB1 as well. EB1 is for people with extraordinary abilities in the arts and sciences when you go as an EB1B, or if you're an intra-company transferee, you come under EB1C. But of late, we've seen that even the EB1 category has been retrogressed, and a lot of people have been held up from being allowed to file their adjustment of status as an intra-company transferee or as an extraordinary persons with extraordinary abilities. Now, based on that, we see why that clog has also come about, and I'll explain why that category got a little backlogged. A lot of people who were in the EB2 or EB3 have also asked their employers if they have a branch outside of the United States, if they could go work for 1 year and come back on an L1A and then apply for an EB1C. So many people jumped from the EB2 or EB3 category into the EB1 category, and we've seen because of that there has been a lot of backlog in the EB1 category. So similarly, we are seeing a pattern where the EB3s jump to the EB2s, and that category has been retrogressed a few times, and also there's a lot of delays in the processing. So we see the trend based on the visa bulletin, how it is, and of course I'll give out the numbers in just a few minutes. Right now, what we see in the last few years is that EB3 has been progressing consistently as opposed to EB2, which has barely moved a week or 2 weeks or 3 weeks at the max, you know. So that's what I can tell you for the moment.
Okay. The next question is, I'm on EB2 with October 2011 priority and my spouse is also on EB2 with February 2014. Do you recommend both of us downgrade or only one? If only one, which one? Please let us know why or why not.
I don't know which one I should tell. I'm not supporting a man or a woman, so that's a decision you guys will have to take, which one. And again, you'll have to see which of your employers is cooperating with you. If the husband's employer is working, then I would definitely go with the husband's employer. If the wife's employer is more uh, workable and he's cooperating, then I would go with the wife's. I wouldn't file both at the same time because let's say in the future, if the EB2 category for some reason moves more rampantly forward, then at least you have one spouse who is able to jump into the EB2 at that point in time and interfile into the EB2 category. So I wouldn't use both of them at the same time.
What are the documents a company need to provide for I-485 filing?
If they are, first of all, downgrading it from an EB2 to EB3, the employer would have to file the I-140. They would also have to give their tax documents to prove that they have the ability to pay. They would also, if the employee doesn't have a copy of the PERM, certified PERM, they would have to give a copy of that and a copy of the I-140 that was approved for the EB2. So those are the documents that the employer has to give. And of course, the employer has to write a letter that they are now requesting a reclassification for this employee from an EB2 to an EB3. And they would like to make sure that the EB2 priority date is still continued and captured. They're not going to lose that. So they would have to make sure that it's um, clearly mentioned in their letter that they would send in support of the amended I-140 petition. And they also have to give what's known as I-485J. I know there are some blogs that I've seen and some attorneys who've said that an I-485J is not required when you're filing an amended I-140 petition. Trust me, we have done some downgrades for a lot of the Philippines and Chinese people back in 2012 and 2014, and when we 2000, I'm sorry, even 2017 and 18, when we had to do that, and because we did not include I-485J, which was very, very new at that point in time, they sent the whole package back saying you still have to provide an I-485J. An I-485J is sort of a reconfirmation from the employer who is downgrading and who's filing the downgrade from EB2 to EB3 that they are still offering this permanent position for this employee. So the USCIS definitely wants to make sure that that particular form is sent along with the I-485, I-140. So that's called as the I-485J. And let me also conclude in that perspective. Earlier, way back, I remember when the 485J was not there and when people even did the AC 21 portability, all they had to do was give a letter saying we are going to hire this individual in this position, or we are going to continue to hire this individual in this position as stated in the PERM and the I-140 approval. So back then they accepted that letter, but now they don't need any letters. All they want is the 485J. So I would highly recommend, because the window of opportunity you have is only 27, 28 days. So I wouldn't take a chance. I would send in all, even if it is a bit extra, I would still send that application along with it. If somebody feels it's extra, let it be extra, but at least you won't get a kickback. The other applications are going to be the I-944 that the employee and employee spouse, every family member, even if you have a child that is 1 year old or 2 years old, they would have to file the self-sufficiency form known as the I-944. They would have to give that. And that is going to be a requirement for all applications that are filed October 13th onwards. There was an injunction on this particular form as well. It was nationwide, then only 3 states continued to have the injunction, and 3 weeks ago, that injunction was lifted, and now everyone is required to file the I-944, which is known as the self-sufficiency document. There's a lot of documents that you have to give with it, which includes your tax returns, bank statements, your credit reports, your W-2s, many other documents. If you have health insurance, you've got to provide health insurance document. So there's a bunch of documents that you have to give with the 944. So please make sure that you send in everything so that you do not have kickbacks. Why that would be disastrous is because the USCIS does not send documents by FedEx or by express mail. They send it by bulk third class mail, and that may take 3 to 4 weeks sometimes for you to get a kickback, and you would lose out your opportunity that you had for the filing. So in my opinion, please file every application. It doesn't matter if it's sometimes not necessary. You're better off giving more than giving less.
Is a medical exam required at the time of filing of the AOS application?
Consistently, the USCIS has always said if you're filing I-485 adjustment of status, whether it's employment-based or family-based, that they require you to do a medical examination and submit it along with your I-485. Even though they are aware that especially employment-based applications are going to be pending for years to come, it may be 3 years, 4 years, 5 years, we don't know. And possibly the medical exam may expire at some point in time, but they still insist on it. However, having said that, we are not 100% sure that they would accept applications without the medical examination under the current COVID conditions, because a lot of doctors are not there full time. They're not able to get appointments with the physicians that are certified by the USCIS. So if that is something that a particular employee faces, that they are not able to get appointments and they somehow tried to get an appointment, they couldn't, if they have some email or some kind of a communication where they said, we can't give you an appointment, I would attach that and send it saying that, hey, I couldn't complete the medical examination, not that I didn't want to, but I was unable to complete the medical examination. So I have a feeling they may be okay with that. But if you are able to, I would go ahead and get the medical examination completed.
Thank you, Mother. Can one exit the country on a valid H-1B and not abandon I-485 application?
As I mentioned earlier, if you do not have an advance parole, you would be abandoning the I-485. It doesn't matter if you have an H-1 and you have an H-1 stamping. Even if you don't use the advance parole to come back, you have actually a visa stamp of your H-1 for another 3 years. You can come back on the H-1B, but if you do not apply and do not receive your advance parole, they would consider that you abandoned your application.
I think next question is also related to the same one. Can someone who has valid H-1B travel abroad and come back when AOS is in progress?
You can absolutely travel. There is no issue to your traveling at the moment. Based on today's law. Again, I don't know what the Trump administration does. Every day we see something new. So based on today, yes, you can. You can also use your H-1B stamp to come back. If you don't have, if you don't want to use your advance parole, you don't have to. You can always come back on an H-1B visa stamp. However, you should be in possession of an approved advance parole so that it would not be considered that you abandoned your application.
Two months from now, when we expect to get the receipt notice, do we pay premium processing fee for each application? That is 485, 140, or is it comprehensive of all applications?
Actually, as I mentioned, the HR Bill 8337 has just come out today, and it's providing the premium processing for number of applications, which I believe is also the EB1, EB2, EB3, and a number of non-immigrant applications like the Ls, Es, including the Hs, H1B, H2B. There are, and the fees is also different for each of these applications. So I don't know as of today, because I don't have the entire information, if you would be paying a separate premium processing for your 485, or for your EAD and your advanced parole. I know there is a premium processing that I read there is for an EAD, but I'm not sure if there is one for the I-131. Now, why would you not be able to file for a premium processing of the 485? Logically is because your priority date is not current. Right now, you're only filing under the dates of filing. Your priority date, even under EB3, right now is somewhere around, let me see, let me pull it up. I believe it is somewhere at 2010. So even if you file a premium processing, they cannot premium process it to approve it because you don't have a priority date that's current. Only thing that you are allowed right now is you're able to file it under the dates of filing. So I don't believe you would have a premium processing for the 485. Now, definitely there would be a premium processing for your I-140. And I would use that, like I said, give it a month or give it at least 2 months so that the USCIS can access your original perm that went in with your EB2 filing. Once they get that, they'd be able to adjudicate your I-140 expeditiously under the premium, and you can get that approved. So that at least the 140 is approved, your 485 is pending. Pending the 485, they're going to issue an EAD and an advance parole. Hope that answers your question.
Yes, thanks, Mother, for the details. Can L2 EAD be premium processed?
As I said, I read the HR 8337 very, very quickly, and they said for applications for employment authorization, the fee is going to be set at an amount not greater. Now, this is how they put the language, as not greater than 1,500. So my understanding is 1,500 would be the max, and it could be lower than that. They haven't said what that amount would be, and the processing time frame, if you file for an expedited request for premium, is not greater than 30 days. So it is not the 15 days, but it is the 30 days. Now, the exact amount, I would imagine it should come out in the next probably 2 to 3 days max, or 4 days. You know, I would give it that much time.
How long can we stay out of US with advanced payroll?
I'm assuming you can stay as long as you want, but then do remember you have an H-1B. You're working with an employer on an H-1B. If you are on an H-1B and you're working for an employer, so it would depend how long that employer is allowing you to take vacation time or paid time off or unpaid time off. So that would depend on that. And if you, let's say, for example, if I take off and stay in India or Japan or wherever for 8 months and I want to come back. So when I come back on an H-1B stamping that I have, and I'm telling the officer I'm coming back to resume my H-1B job, that individual, the officer, would have a question, do you really have an H-1B job because you were out there not working? Now, but the opposite of that is if I'm on an H-4 and I have an EAD and I'm working on an EAD and I'm just taking time off, I can go to India and stay there as long as the I-131, the advance parole, allows me to stay. I need to come back before it expires.
Okay. And what are some of the issues that we will face if we upgrade from EB3 to EB2 later?
Whenever you do an upgrading, you're going from lower classification, not in a bad sense when I say lower. The EB3 requires a bachelor's degree, whereas an EB2 requires either a bachelor's with 5 years of progressive experience or a master's degree. So your employer would have to go through the entire perm processing and the I-140. So they would have to redo the entire application. However, they can come back and recapture the priority date of your EB3. Let's say that was 2012 or 2013, and they're filing the EB2 now in 2020. You can still go back and recapture that date. So you would be at that advantage for advancing so many years.
Okay. Next question is related to the same above question. How long does it take for downgrading from EB2 to EB3, and how long does it take, considering the volumes of the applications, to complete the 485 process?
They cannot complete your 485 process. Your 485 will be pending because your priority dates are not current. So there is the process only happens only to the extent of granting you EAD and an advance parole. They'll do your biometrics, they'll do your EAD and advance parole, and after that it remains there static until such time that your final action dates move ahead. If your final action date, that is your priority date, is current, then they will adjudicate the I-485 so that you can get a green card. And we've seen in the last 1 year to a year and a half that I-485s, employment-based I-485s were scheduled for interviews, and once at the interview they feel that you have complied with everything, they give a green card. Then there's also the other way that I've seen, even last year in 2019 and this year in 2020, that they have approved the employment-based green cards even without the requirement of an interview. So we've seen both ways, but they will not process your 485 until your priority date becomes current. And I believe the other question was, how long will the I-140 take? We can only give you a rough estimate. It may be 6 months, it may be 8 months, or could be less than that. But having said that, as I mentioned, that once you file it, once you receive the receipt, notice of receipt, give it a month or two, and then you can request for a premium processing so that your I-140 can be approved, let's say in about 2 to 3 months. It's just an approximation. But if you don't do the premium processing, then you can just continue with it, and it may take about 5 or 6 months. I'm just giving an approximation.
Okay. If we apply for EAD, does it come with an end date? If yes, and if we don't plan to use the EAD of EB3, should we still keep renewing it?
You will get an EAD always with expiration date. There's no date without an end date. There's always a start date and an expiration date, whether it's an H4 EAD, whether it's a 485 EAD or an L2 EAD, everything carries an expiration date. Now, you can use it or you don't have to use it. Assuming you don't want to use your EAD because you still have to maintain your H1B status, if you don't want to spend the money, because as you know, with the fee hike, they came about saying you have to pay $550, I believe, for the renewal of an EAD, even for a pending 485 EAD. So if you don't want to spend that money, I would not get it renewed. And there's nothing wrong if you don't get it renewed. It's not saying that you're no longer continuing with your 485 or that they will deny your 485 if you don't file for the renewal of your EAD or your advance parole. So that's going to be a personal choice at that point in time. If you feel the fee hike is hurting you and you don't want to do it, you don't have to.
USCIS increased the fees, but the court put a temporary suspension on this file increase. So after submitting the petition with the old fee structure, if the new charges come into effect, what happens to our submission?
Absolutely. A wonderful question, which is what I addressed earlier. Today is October 1st. We have an injunction in place, which is called as the preliminary injunction. Now, we don't know if the government is going to file an appeal on this decision, and I'm I would imagine they want to file an appeal, because if they don't, they are losing out on thousands of dollars. And as you all remember, they were going to furlough 13,700 workers by August 31st, and they held off that. And because of that, they came up with this fee hike. USCIS is a fee-based agency, just like the post office is. So the government doesn't give funding to the USCIS because it's a fee-based agency. So they would definitely want to come and appeal this decision. And I'm pretty sure once they appeal, I don't know if the judge would continue with the injunction as a permanent injunction or another temporary injunction, or would support the government's argument that they should increase the fees. So we don't know how it's going to go. But let's assume that I'm just giving a random date. Let's say on October 15th, the court comes and says, now the government is right and they should be allowed to increase the fee. If they do that, then whatever day the decision has come, the fee hike is effective from that date. So if the decision came on October 15th, please make sure that if your application is going out on the 16th or on the 17th, you would be filing it with the increased fee. Now, there's going to be some situations where you sent off the application on the 14th with the old fee, and then the judge said that the fee hike is effective 15th, and your application reached there on the 15th. We don't know how that's going to happen. We hope and pray to God that the judge will, at least when they grant the injunction in favor of the government, would at least give a forward date saying, October 22nd or whatever date they would give, some time, so that people who've mailed these applications are not in that, a twilight zone. They get stuck in the twilight zone. So hope it answers your question.
Yeah, sure. Next question is Ms.Uma garu. Thank you for your time. My priority date is March 16, 2015, filed in EB2. However, it doesn't meet into EB2 or EB3 filing dates. Please advise if we need to consider downgrading to EB3 and be ready with the process.
Would you repeat the priority date for me one more time, please?
March 16th, 2015.
And that's an EB2, right?
Yes.
Okay. Definitely you won't be able to file under the dates of filing with the EB2, because the EB2 dates of filing are May 15, 2011. Now you don't even come under the EB3 even if you downgrade, because the filing dates are Jan 1st, 2015. So you're a few months away from that. So you may not be eligible to file it. Now, we don't know if the next bulletin will give you that chance, or the bulletin in December will give you that chance. You'll have to wait and see. But as per this bulletin, as per the October 2020 bulletin, even if you downgrade it, you don't qualify for it.
So I think they're asking, will there be any advantage if you just downgrade and keep it in EB3 for now and be ready?
I wouldn't do that. I wouldn't do that. I wouldn't do that for two reasons. What if the EB2 advances? So you would feel miserable for no reason. You've downgraded yourself. So I would hold on to it and wait and see. If the visa bulletin, let's say for November or December, moves to, let's say, for example, till June 1st, 2015. I'm just giving a random date. So if it does, then at that point, you can always downgrade it and file it concurrently with your 485. I wouldn't downgrade it now.
We have a newborn and did not receive the birth certificate yet. Can the child be added later after submitting the application?
Absolutely. As long as you have mentioned the child's name and date of birth, that is fine. If you received any documents at the hospital, sometimes the hospital gives a little, I won't call it a certificate, but a fancy thing with the baby's footprints or handprints that the baby was born on a certain date. You can just give that and say that the birth certificate is on its way. So that should be fine as long as you include the child and you will be saying that this child is not applying with you.
The other question is, can a company apply under a different SOC code under EB3?
You mean downgrade from EB2 to EB3 with a different SOC code?
Yeah, I think that's what they meant. Yeah,
Okay, if that is so, no, you cannot. The reason being you're basically porting everything that was on the EB2 to the EB3. You're just reclassifying the job under EB3. So you cannot change the job location, you cannot change the job duties, you cannot change the prevailing wage, you cannot change the SOC code. You cannot even change the location. For example, if your employer was in Houston, your EB2 was approved for Houston, and let's say now the employer has moved to Boston. Even while doing the downgrade, you will have problems because the entire perm, the recruitment, everything was done for Houston and not for Boston. So you would have issues. So they cannot change anything that is stated in the certified perm. So be very, very careful of that. Because I have a few clients who are in that situation where their employer had filed the EB2 or even EB3 and it is current now, including the final action dates are current. However, the employer over a period of time, it's been 10 years or more, have moved from one state to another state. So they're having that problem that we have to prove that they cannot port this to another state, another city, because the USCIS will not approve those cases. They have an issue. So you have to make sure everything matches as per the certified 9089.
So my employer has mentioned they will be closing their engineering office by end of December this year. However, they will be willing to file my I-485 along with EB2 to EB3 downgrade. Since they are closing their engineering office, can I transfer H1B to another employer and file I-485 simultaneously?
You cannot file a 485 with a new employer unless that employer has filed for your perm and I-140. You can downgrade it at that point in time, but I don't think you can do that. But having said that, now if they are closing their engineering services and you work as an engineer but you don't have a job with them, you can move your H1 to another company, but they can still continue to process your green card. Are they closing the entire business, or is it just one section that they are closing, one department? Now, if they are closing the entire business, you're going to have problems. But if they're just closing one department, but you can still continue to work for the employer with the same job, same position, same prevailing wages, they would still be able to continue with your EB2 downgrade and doing the 485 and the 485J. I would do everything at the same time. I wouldn't even wait to do the 485J much later.
I have a December 2009 priority date in EB2. Can I downgrade to EB3 given the final action date and refile of I-140 and I-485 under premium process?
Absolutely, you can do that. And your 485 would be adjudicated or processed further because the priority date is current. You're one of the lucky ones. And I would do it. I would absolutely not wait even one single day. If your employer is cooperating and willing to do this, I wouldn't even wait a minute. I would jump in.
Okay.
Don't miss this golden opportunity. Like we say in Indian languages, Lakshmi is coming and knocking on your door. So don't lose it. Take it. Run for it.
Definitely, I think all of us are running for it. Okay, the next question is, if EB2 final action dates gets current and I downgraded to EB3 and haven't used EAD and advanced payroll, what is the process to file in EB2?
Well, if you haven't touched the EAD and the advanced parole, basically, when you're filing by downgrading, you do get the EAD and the advanced parole, and it's like an insurance policy. You get that, but you don't use it. And if you haven't used it, as I mentioned, your EB2 remains unchanged. There is nothing that has affected it, even by filing the adjustment of status, because you're not sort of married to the EB3 category because you've not used the advanced parole and the work permit. So what will happen is you can now jump back to the EB2. Your employer will say, now I would rather keep him in this position rather than in the other position. I want to file for him for a green card. My opinion, you still have to file an amended I-140 again at that time, even though you had an approved I-140 for the EB2, because you have now come and downgraded it as an EB3. So there'll be a confusion, are you in an EB3 or an EB2? To avoid the confusion, the employer would file an amended I-140 again under the EB2 category, and they'll see that you've not used the EAD or the advanced parole, you've not used any of the benefits under the EB3 filing, so they'll bring you back into the EB2 filing, and you will continue to get your green card under that process. And during all this process, I've seen a lot of people asking me this question repeatedly, and I'll say this to many of you, is that many people ask me, I have an EAD because I filed for the adjustment of status, so can I now not continue to renew my H-1B? No, that is not true. You need to continue to maintain your H-1B status until such time that you get the green card. So please don't do that by taking away your H-1 status. You need to continue to file for your H-1B extensions. So you need to maintain your H1 or H4 or whatever status, L1, whatever status you are maintaining, you need to maintain that till you get your green card. Why am I bringing L1? There may be people in this webinar who are in the EB1C category or EB1A, EB1B category. So, if you qualify under that, under the dates of filing, you still need to maintain your L or your H1B status. If you don't do that, you may not be eligible for the adjustment of status when the final round comes through, when your priority dates become current.
Thank you so much, Uma garu. Thank you, Indira garu. So, Uma garu, we have a lot more questions here. Let us know when do you want, how far do you want to go? I'll continue with these questions here, but it's 8:20 and we have this scheduled till 8:30, but the session we have scheduled Zoom till 9:30. So you let us know how far you want to do this, and maybe we can ask them to send these questions to email us if we can't get all of them, and we can send them the response through email.
Indira garu and Geeta garu, I am available. I this evening I have dedicated to Sneha Hastam and TCA and to all these people who are attending the webinar. The purpose is to try to at least give each of these members who are attending the webinar a guidance. Individually, I cannot resolve each one of your problems. For that, they have to reach out to me. But I can generally, I'm trying to give answers, and I have no problem continuing. I don't know about you all, but only thing I will ask, someday TCA has to give me a dinner.
For sure, Uma garu.
No, I'm just
For sure,
kidding.
yeah.
I'm just
Call me
kidding.
with your answers every time. Sorry, I have to interrupt, and I'll take this 1 minute to add a few words. Magaru, seriously, subject matters like you and being with the passion that you have to give back to the community and being responsible to take this, to answer everybody's questions. It's really delightful to see the way you're motivated, and you motivate us all. Thank you so much for taking the time. Thank you for extending the time.
My pleasure. As I mentioned right in the beginning, Geeta and Indira, Sirisha, I was a candidate like all of them. I was going through the immigration process. So I know where it pinches. I know where it hurts. And believe me, during my time, it was not as difficult as it is right now. So I see the pain, I see the suffering. Somebody's been on an H1 for 10 years, 12 years, 15 years, and each time they have to either change employers, they're paying for their extensions, their amendments, their spouses are not getting their H4 EADs in a timely manner, they were losing jobs. So this is all extremely painful. So, I mean, I have to be thankful to TCA and Sneha Hastam. Every time I have reached out to you all, I don't think you've said no to me that I want to do this webinar for the community. And you guys have stood up, you're my backbone. You've been, doing this for the community. I know we've done several immigration seminars. I've even done a seminar during Harvey for people, so I'm part of this community and I really feel passionate to do something for the community.
Thank
And
you for
I'm
your
grateful that you have given me this platform to come and express all these views of mine, what I know.
very humble of you, Uma Garu. Please proceed. Thank you so much.
Sure. Go ahead.
Yeah, thank
I'll
you,
just take a
Magaret.
sip of coffee and then
Sure.
we'll continue.
Sure.
Go ahead.
So this question is, I was unfortunately involved in a theft case. We got
Okay.
citation and only penalty was fine. This was dismissed though. My question for you is, should I list the citation in the paperwork?
You have to absolutely list it because when they do your biometrics, ma'am or sir, they would see that there was a theft is not just a citation, it is a criminal case, depending on whether it was a class A or a class B misdemeanor, or I don't know if it was a class C misdemeanor. Whatever it may have been, they would get this information through the biometrics. So we need to be as honest as possible, not that you were trying to lie, to let them know that a mistake happened and the case has been dismissed. You need to provide them with certified copies of whatever the court disposition was, along with your I-485 application, so that you don't have problems in the future where they would come and say, well, you never told us this happened, or you were trying to hide something from us. So the best thing would be, yes, I would definitely do that. I had a few clients in a similar situation where somebody was charged with a DWI, or somebody I know was charged with selling liquor to a minor. I know these are minor things, but we still listed them when we sent off the applications in the last few days. So I would definitely do that. I wouldn't be too worried about it. I would be concerned to make sure that I'm listing it and get the certified copies. And if you have questions on that, please reach out to me.
Okay. You mentioned we should file amendment of I-140 for downgrading from EB2 to EB3. My attorney is saying do a new filing, not amendment, as if the amendment is rejected, you may lose the original I-140 of EB2 also.
When I say the word amendment, you are amending it and declassifying it from an EB2 to an EB3. You are going to classify it as a new petition, but you're basically amending the whole thing. You would be filing it as a new application. The application is new, but you are declassifying from an EB2 to an EB3. So your attorney, I'm sure, knows what he or she is doing. But when I use the word amendment, that's what I'm saying. I'm declassifying myself from an EB2 to an EB3. And I would also, like I said repeatedly, that I am recapturing the priority date of my EB2. If you don't put that, the officer doesn't know what you're doing. If you just put it as a brand new application, they're going to process it as a brand new application without recapturing your EB2 priority date. That's why you have to be extremely careful when you do this.
Okay. For how much duration we get the EAD card? Does this varies for each applicant?
Yes, it does. From what we have seen in the past, sometimes for an employment-based adjustment of status for an initial EAD. Sometimes they give it for 2 years. And we've even seen where they've given it for 1 year. Now, looking at the current situation under COVID and looking at USCIS, who says they've lost a lot of money during COVID period because a lot of people did not file their applications. They didn't make as much money. So my assumption, this is just my assumption based on their fee basis, because they're increasing the fee, they want more money. So my assumption would be that they'll probably give it for 1 year so that if you file for a renewal, you'll be paying for that $550. So this is one way for them to get money from you. Earlier, employment-based or family-based green cards, when the fee hike was not there. Of course, right now the injunction is there. Whenever it comes back, and if it does come back, they would be charging even for the renewals. In the past, if you filed an adjustment of status application, family-based or employment-based, for the renewals, you never paid any extra fee. But this is the reason why they introduced the fee, so that they could collect it for the initial as well as the renewal. So it's just a educated guess that I'm making, that they would give it for 1 year, and possibly the reason being they can charge the fee.
Okay. Next question. How long it might take to reach final action date?
Like I said, I'm looking for the Aladdin's magic lamp. Or I need to get one of those parrots from India, from one of the stations, railway stations, where the guy used to sit with a parrot and will tell you exactly what's happening in your life. Believe me, guys, none of us know these priority dates, how they move, whether there's going to be a retrogression or there's going to be an advancement. We just don't know that. And if somebody is giving you those dates, I don't know, I'll take it with a pinch of salt. For me, I trust the visa bulletin. Now, sometimes the visa bulletin will give us indications that we may see better advancements in the EB2 or EB3 categories. So that would be an educated way for us as attorneys to tell you all, okay, this is going to advance a little more because this is what the visa bulletin is indicating to us. So based on that, we can give you an educated guess, but without that, I really have to get one of those parrots.
What will happen when our downgrade is in progress and EB2 dates become current?
As I mentioned, that's providence of life. You're driving on 59, you're in the third lane, and then you see the second lane moving faster. You get into lane 2, but then suddenly lane 2 is all clogged up because everybody moves into that lane. That's exactly what can happen. And if that happens, then people may want to do the interfiling and go back to the EB2. Now this is the swing that has been happening for India, particularly India and China also. Back in 2018, as I mentioned to you all, China had the similar phenomenon that happened where the EB3 cutoff date was advancing and the EB2 was, kind of stuck. So they did the similar situation where people downgraded and went in. And then when they did that, they noticed that the EB2 went a little more ahead. So this can happen. So if you do that, and if you've not used the EAD and the advanced parole, then you can definitely, since your EB2 filing has remained intact, you just have to go back to that and refile your applications along with the adjustment. If EB2 is moving forward, I would do that.
Thank you. If I am porting from EB2 to EB3 from the same employer and cannot locate my labor, will there be a problem?
If you cannot locate a copy, I would ask your employer at some point in time or immediately to reach out to the Department of Labor and see if they can issue a duplicate that you are intending to file a downgrade and you lost your copies, and if they can probably issue a duplicate and they won't issue it to the employer or to the attorney. They can sometimes send it directly to the USCIS. So you may want to do that, or if you want to wait to get the receipt, give them the notice of receipt, then they would send it to the USCIS. And you can tell the USCIS that you've misplaced, you don't have a copy, uh, that's all you have is just the I-140 approval. As I said, they still have to go to your original file of your EB2 filing, wherever your original ETA 9089 the certified perm is there, they'll have to get that from that file. So it takes them a while to get that. So in the meantime, if you do not have a copy, this is how I would work around, by letting them know you don't have a copy, you've lost it, and you're filing it with the copy of the I-140, and your attorney or you have requested the Department of Labor for issuance of a duplicate because you've lost this. If you have any emails, letters, I would ask the attorney to include all that.
Okay. After the downgrade to EB3, once we get EAD and we use it for a certain period, and in future if EB2 final dates become current, can I switch back to EB2 and use current EB3 485?
It's a very good question, and it sometimes can be a tough question to answer. Yes, you can. Once you filed your EB3, you've downgraded from an EB2 to an EB3, and you filed the I-140 and the adjustment of status. Now, as I mentioned to you, the EB2 remains intact. That is not affected, but the fact is that you have used the EAD and the advanced parole, so you've used the benefits of the EB3. So because you've used the benefits, they feel like you can't be having the cake and eating it too. You got the benefits here, now you want to come and get the benefits out of EB2, which is, what they don't appreciate. There is a process to that. It's a lengthy process, and that's something we'll have to discuss some other time, because it's a huge process that one has to go through. But there is an availability of interfiling, and you'll have to explain to them uh, more clearly why the EB3 job is now not available, and now why the EB2 job has become available. This is going to be a tough one to do, and you'll have to explain to them. So instead of that, what you could do, if you don't want to go through that, there are two ways of trying to come around, and I'm just saying this. Let's say you've used the EB3 and you've used the EAD under that and the advanced parole, and you don't want to go through the sticky process of going back to the interfiling of the EB2. And if you want to do that, the way I would do it is ask the employer to file a brand new EB2, but they can still recapture this date in the meantime, and they can use that. If not, you can always, if the 485 is pending for 180 days or more, under the AC-21 portability, you can try to port it to another employer. So that's something you may want to do. But if you want to go back to EB2, this is the way I would do it. I would not go back to reusing it, because you're going to have a lot of problems. I would just ask the employer to go ahead and do a perm, do the I-140 with a brand new application, but you're still porting the old date, and you can still come back to it without much of a lot of problems. This is the way I would tell you all to do it.
Okay. Can we use EAD to travel out of country and into US, and H1B for working?
You cannot use an EAD to travel. You would be using the combo card. It comes as a combo card, which is both the EAD as well as the advanced parole is in one card. They issue it as a combo card. Once you get that, you would be using that combo card as for traveling, which is the advanced parole. Now, let's say the new fee kicks in before October 29th, and you're just filing for an advanced parole and you're not filing for the EAD. Then you just get the advanced parole card, and you'll use that to come back into the country. You will be working on an H1, so you will come back and you will resume your H1B job as you were working before you left the country. Now, some people even do this, like I said, back in 2012, 2018, when we had a similar situation. People would get the advance parole, never used it, but they had the stamping, so they would use the stamping to come back on an H1.
Okay. Can we withdraw this downgrade application if we decide after we file?
Absolutely, you can. You're just going to lose money that you paid them. They're not going to refund. You know that.
Okay. My perm and I-140 was approved with job title molecular biologist and priority date EB3 2013. I transferred to an IT company as data scientist after I graduated from MS in IT. My question is, can IT company use my priority date as it is completely different job title?
Yeah, they can recapture the priority date. They're not using that perm, they're not using that job because it may not match your skill set right now. You were a biologist, a molecular biologist, I believe, and now you're more of an IT person. So they can use they can recapture the priority date by filing a brand new perm and an I-140 with your skill set that you have right now.
Okay. Is there any cutoff on the applications that USCIS receive by end of October?
Sorry, say that again. I missed out.
Is there any cutoff on the applications? I think
There is no
number of
cutoff.
applications.
No, they're not saying we'll accept only 100,000 or 200,000. They're not saying that. As many people who qualify can apply. But the only thing is, as of right now, per the bulletin, your date is October 29th, 2020. You have to mail out your packages by that date.
Okay. What are the travel restrictions for family while processing I-485? Is there a way that spouse of primary applicant can travel to India? Spouse has a separate H-1B.
Yeah, the spouse can definitely travel, but if the spouse is applying for the I-485 adjustment of status, that spouse has to still receive the advance parole before traveling. Otherwise, he or she will face the consequences of abandoning his or her application. So even though they are on an individual H1, they'll come back to resume their H1, which is fine, but they have to have an advance parole for traveling, and they can return back on an H1B.
Okay. When I-485 is pending, can I travel to India by using my valid H-1 visa and not using advance parole?
When you're leaving the country, it doesn't matter what you travel on because you're leaving the country. When you're coming back, you can use your H-1B visa stamp to come back into the United States. However, the officer may want to see that you've not abandoned your application. Are you in possession of an advance parole? Do you have it? An approved advance parole, which means then they will not now decline or deny your I-485 because you were in possession of it. You've not used it, but you're in possession of it. So that way your I-485 is not abandoned.
Okay. I have done my master's in US. Is it risky to downgrade from EB2 to EB3 as EB3 doesn't really require one to have master's?
No, there is no risk involved if you're downgrading from an EB2 to an EB3. Absolutely, you already pre-qualified when you applied for your EB2 that you do have a master's degree for the skills and for the job that is required. You've proven that. But you meet the minimum requirements of an EB3, which is a bachelor's degree. So you will meet those minimum requirements. And sometimes it can be a bachelor's degree with 5 years progressive experience also. So it doesn't matter. Like, for example, I've seen where we have filed an EB3 for a employee who's got a PhD. And it's not uncommon. Just because the person has a master's degree, that doesn't matter. It is the job requirement that is important. What does this job require? Does it require a master's degree? Does it require a bachelor's degree? Since your perm already states what it requires, whether it requires a master's or a bachelor's with 5 years progressive experience. As I mentioned, when you file your downgraded I-140 and you're reclassifying yourself for an EB3, you have to prove that you meet the minimum requirements, which may be the bachelor's with 5 years or a master's.
Okay. Does AC21 requires you to have a EAD already in hand?
No, it doesn't. Absolutely not. AC21, which was passed by Clinton way back in 2000, clearly said that all you need to do the portability under AC21 is that your I-485 had to be pending for 180 days. If you have that and you have an employer who's in a similar business and can offer you a similar position and provide you with the same prevailing wages, you can port it to that employer. You don't need an EAD. You don't even need to apply for an EAD.
Okay, thank you. Is it possible to file advance parole in premium processing along with EAD using HR 8337?
Absolutely, I know about the EAD. I'm not too sure about the advanced parole. As I mentioned earlier, I haven't got a clarity on that as yet, whether they are allowing it for the I-131 applications, but I know I have clearly seen that they are providing the service for the EADs. I believe you'd be paying a fee of 1,500 up to 1,500. They said the word is up to 1,500. It could be less than that, but that's what they're saying. And the period that it would take for them to process is not 15 days, but it's going to be 30 days.
Okay. Should children move to F1 visa if they reach 21 years and the final action date is not current, though children got EAD before 21?
Absolutely. It's a very good question, and I'm glad somebody asked that question, because I see a lot of parents and children making that mistake because they assume, let's say, for example, if that child is on an H4 and the H4 validity date is still, I'm just giving a random date of October 1st, 2022. The parents generally assume that even though the child has reached 21, because the H4 is valid till October 1st, 2021 or 2022, that the child can still continue on that H4. They cannot. If you're on an H4 or an L2 and your child is reaching the age of 21, I would highly advise the parents to start the process of the F1 at least a year ahead. The reason being the F1 process takes anywhere between 8 to 12 months. So you do not want your child to be out of status if they're reaching the age of 21. Yes, they have to jump from an H4 or an L2 to an F1 status. And now, even though they were given an EAD pending the 485 and the priority date is not current, they may not be eligible to get further extensions of that EAD because they've reached the age of 21. Now, what happens to their application? The application will remain when the priority dates become current, and if there is an interview, the officer will determine if this child is entitled to get a green card under the Child Status Protection Act. Now that's something, it becomes a little more complicated to see whether this child qualifies to get the green card under the CSPA Act. But the child will not be entitled to get further extensions of the EAD because he's no longer a dependent on the parent and he's lost that status and he will not be eligible for that.
Okay. Once you get the EAD, technically the I-485 is in pending status until priority date for final action is current. Are we still dependent on the employer for documents when the PD is current for final action date?
Good question. Under the current policies, yes, sometimes the USCIS, when they schedule employment-based interviews, we have seen them asking for documents from the employer, which could be a current tax return or to show that the employer still continues to have the ability to pay for this employee. Sometimes they don't because we submit the employees W-2s. If the employee is working for the same employer who is petitioned for the green card, then they don't have to go to the employer's tax return because the employee is able to prove that he or she is working for that employer who petitioned for their uh, EB2 or EB3. But um, in many cases, we've also seen that they don't have an interview, even though the policies changed almost a year and a half, 2 years ago. Don't remember the exact date, where they said all employment-based applicants will have to go through an interview process. But we've seen that being waived and they would just mail the green card. Now, what will be the policy 3 years from now, 1 year from now, 5 years from now? I don't know that. And if the Trump administration and President Trump comes back after November 4th, if he's elected the president, will this administration continue to be stringent and continue to require documents? I'm pretty sure they will. We've seen how this administration has been extremely strict for everything, for everyone, whether it's an asylum, whether it's an L1, or whether it's an H1 or an H2B or an F1, whether it's a VAWA, DACA, it doesn't matter. You know, they've been very, very stringent on their requirements. And if this administration continues, I definitely would expect them to be continuing with more stringent policies. So now, will your employer be able to give you those documents when your priority date comes? That's something, you know, you'll have to maintain a good bridge, a good relationship. If you're not working with that employer, I highly recommend you to maintain good relationships so that your employer is in good terms so that they can work with you. And if you're already with that employer, I feel you may have lesser problems. But I'm not suggesting that you have to go work for that employer.
Okay. My previous employer has my approved I-140. Do I need to be on his payroll for him to file my I-485?
Absolutely not. Your employer, previous employer, can still file the I-485 and the amended slash new I-140 to downgrade your EB2 to EB3. You don't have to be employed with that employer. And because he'll be giving you an I-485J, he is clearly indicating that he is willing to continue with your green card application, even though you are not currently employed with him, because you'll be showing your H-1B documents with the employer B. So there's no issue with that. And neither does the USCIS have any objections to that.
Do we get stuck to an employer when downgrade is in process?
You don't get stuck, but there is always that, you know, relationship. It's like a marriage. Are you stuck with your wife or with your husband? You're not, but to maintain and to continue, you know, to grow together, there's a relationship that you maintain. Your employer is achieving something through you because you're a good employee, you work hard for them, and you know, give them all the results that they are expecting from you, so they're happy with you. And in turn, they work with you saying, hey, I'll work with you when you need your green card. I'll do everything that I need to do because you're a valued employee. So I guess it's a relationship that you build up and you maintain it. Just like anything else, you know, you maintain a car, you maintain everything. So you maintain this relationship. So you're not stuck as such, but there's a relationship that you maintain with that employer. And the reason for me to say that is, it's not like the olden days where people were employed for 30 years, 40 years with one employer. These days, life is beautiful. People can jump from employer to employer, several employers, because you have the opportunity to do that. But then when you have these green card issues, and if you burn your bridges with your previous employers or your current employers who are doing your green cards. So that's where the little hitches come or the little hiccups come. So I would suggest, do the best you can, because I'm not in your shoes. I won't know exactly, but I would just do the best I can.
Okay. I understand that we need to file with new I-140 as amendment to original I-140. We filed downgrade and now EB2 dates moved ahead my priority date, and I want to file in EB2 now. Will there be any impact to original I-140 as we amended it while downgrade?
Absolutely not. As I mentioned earlier, when you downgrade for your application or you're reclassifying yourself from an EB2 to an EB3 position, even though that is the same position, you're amending and filing as an EB3. Your EB2 application remains intact. Now, if you do not use your advance parole and your EAD, you've not used any benefits that you filed under the EB3. It was merely an application which is pending. You've not used the advance parole, you've not used the EAD, so you've not gotten any benefits out of the EB3 application, even though your employer downgraded it for putting you in a line that is taking you ahead at that moment. But if you decide, I don't like this, I just want to go back to my EB2, I'm happy with that, I want to continue as an EB2, you just withdraw this application. And since you've never used any benefits arising out of that adjustment of status application, you will be free to go back and continue if the priority dates become current under the EB2 to file your application and move forward with that. And of course, the USCIS will be well aware whether you've used your EAD or you've not used. They would know that pretty much.
Okay.
And I must say one more thing. This, as I said, this happened in 2012 and 2018, particularly with the people from China and people from Philippines. I've done a lot of their cases, and I had one client who filed a downgrade from EB2 to EB3, and then that individual had to travel on an emergency and used the advance parole because he did not have time to go to the consulate to get a stamping and come back. Even though he used it that one time, they never counted it as though that he used that, and they let him go and we could come back and refile it under EB2. But that's in a rare situation. I'm not suggesting people should do that. I'm just saying it happened, and that was one-off case. And for whatever reason, the USCIS was not too upset with that.
Okay. I have I-140 approved with a previous employer and filing date is now current, August 2010. Current employer's GC processing is in perm stage, and if previous employer wants to file for I-485, should I work with previous employer immediately after filing 485 or after getting GC, or can I continue working with the current employer on H-1B until GC is approved?
Absolutely. You can file your I-485 with the previous employer with whom you have the I-140 approved. I believe you mentioned a priority date of August 2010, which is absolutely current, and it's an EB3, so I'm assuming you can proceed on that. And you don't have to go back to work for the employer who petitioned for you. You can continue to work on an H1 for the current employer that you are with. However, once you get a green card, not the work permit, once you get a green card, you are required to go and work for the employer who petitioned for you, through whom you got the green card. By law, you're required to go work for that employer. Even though you may do a second job with employer B or employer C, you are required to work for employer A who petitioned for your green card.
Okay, here is another prediction question. As huge number of EB2 downgrades are happening, can we expect EB2 to move forward quickly?
We don't know that. We don't know how EB2 and EB3 will play out, whether, let me back up and say there's been a long discussion for the last at least 5 months, 6 months, where a lot of family-based immigrant petitions were not used because of the ban, the proclamation that the president had announced. And so a number of family-based green cards have been unused. And the Trump administration had mentioned this a while ago, that they're going to take those family-based green cards and infuse it into the EB2, EB3 categories, particularly for countries like India, China, which is quite severely backlogged. So if they do that, we haven't seen that they have done this even for the October visa bulletin time. We don't have an indication that they've done that. Assuming that they come and do that in the month of November or December, we may see a big increase, in moving forward of the dates, whether it's EB2 or EB3 also. We don't know that. We are hoping and praying that they would. And the ban was a blessing in disguise, because some of those family-based petitions where the visas were unused, they're going to now use it for the employment-based petition. And if that happens, um, ladies and gents, that'll be a great thing where EB2 and EB3 will move forward. And I think we all will be the happiest.
Can you apply for EAD now and advance parole later and continue to work or travel on H-1B?
Absolutely. When you file for your application for adjustment of status, you can decide if you want to just file for the EAD or just file for the advance parole. You don't have to file it as a combined application, or you don't have to file either one of them. That is your decision. Right now, under the current fee, there is no fee for the advance parole as well as the EAD. But should the new fee kick in, they're going to charge $550 and $590 for each of those applications. So at that point, if it kicks in, let's say in the next few days, then if you file any one of them, you're going to have to pay the fee for that. But you can decide, I don't want an advance parole, I just want an EAD, or I don't want an EAD, I just want an advance parole. That's going to be a decision you can make. Absolutely.
Will there be any disadvantages if we downgrade to EB3 and file for EAD or green card than file it in EB2?
There are no disadvantage as such, like I said, but if you use any of the benefits that you got under the downgrading process from EB2 to EB3, you're using the EAD or you're using the advanced parole, then you're kind of stuck to that category because you've used the benefits. So once you've used the benefits, like I said, you can't have the cake and eat it too. You can't say now, you know what, I've used it, I'm fine now, I want to jump to EB2, which is why I said there's going to be a very sticky situation. And in my opinion, even though we file an amended I-140, they're going to have issues with it because you've used the benefits when you file the EB3 and you conveniently use that. Now you want to conveniently come back to EB2 because the EB2 is moving much quickly. So, you can't have the cake and eat it too is the policy they have. And I'm sure all of you would agree to that. Even in normal circumstances in life, we can't have the cake and eat it too. So if you're wanting to at some point jump into EB2, don't use those documents. Or if you feel, hey, I'll be tempted to use it, don't even apply for it. Just don't apply.
What is your guidance to the family members who are on H4 in the event when the petitioner or permanent residency application died? Would section INA 204I apply to us?
Would you repeat that question again for me?
It looks like the primary applicant in the event, the primary applicant is died. What is the status guidance for the family members who are on H4?
Okay. Typically, when the employment-based principal applicant, which is the employee who filed for the downgrade under from EB2 to 3, now it's pending, and unfortunately, if that principal applicant dies, typically that application could be a dead issue. However, under 204J, there is a discretionary thing that we could reach out to the USCIS on humanitarian grounds, but that is a very discretionary thing. Whether they would apply that rule and allow the derivative applicants, which is the spouses or children, to adjust their uh, to adjust to a green card based on the application that is pending, even though the principal applicant is dead. Now, we've seen more of these kind of discretionary grants in a family based where the principal applicant, let's say, for example, a father petitions for a child and, the petition has been pending for 10 years and the father dies and, these children have been waiting for 10 years or 12 years. We have in my office, we filed for the discretionary relief to the USCIS saying this family was waiting to reunite, and before they could unite, the father passed away, and if there is a mother who's living here alone, then they can say that there are compelling circumstances for this family to join so that they can give some relief to the rest of the family members. Now, in an employment based situation, I don't see the compelling reasons what the spouse can say that they can provide to the employer. So that can be, again, a case by case, very discretionary on the USCIS whether they would approve it or not. Because there's nothing compelling at that moment, even though the situation is quite similar. Here it's an employer employee, there it's a parent child. They give more discretionary humanitarian cases that have been approved when it's a family based as opposed to an employment based. I know it may sound unfair, but I'm just telling you what typically is done.
Is there a difference in the EAD that the primary applicant receives and the spouse receives? Say if the primary loses job after getting the EAD, would there be any impact to spouse?
No, absolutely not. It's an EAD based on a pending adjustment of application for both of them. The primary applicant also is filing for the adjustment of status and applying for the EAD. So is the derivative, she or he is applying. Both of them get two separate EADs. Neither one is connected to the other because they are two separate applications. So it has no connection. Now, if the primary applicant loses his or her job while the adjustment of status is pending, I would expect that person who's on an H1 to find a job immediately within the 60-day period, which is right now the 60 days. We don't know if it'll be 60 days, 90 days, 30 days in the future. So during that period, I would go ahead and try to find another employer who's willing to do an H1. Now, let's say they feel like I don't care, I want to be stuck in EB3, I'll continue with EB3, then that individual can even use the work permit, but I would still find an employer to do the H1 so that they don't fall out of status, even though that individual uses the EAD during that interim period. So the spouse has nothing to do with the derivatives loss of an H1 job.
Okay, thank you. Do the medical exams done expire in 6 months from the date of exam? If so, is it better to get the exam done when the interview date is near?
They don't expire in 6 months. They typically, generally speaking, they expire in 15 months. However, recently we have seen when people take medical examinations, they go by the date they took the exam, and they are giving an extended period. I believe it is either 2 years or 3 years. I'm not sure. They give an extend. This is based on family based as well as employment based. Now they don't expire in 6 months for sure. Coming back to the answer, should I do a medical examination afterwards and not submit it along with? Like I said, I don't want you to have any issues for them to reject an application. Please remember, right now, the Trump administration has been losing so many lawsuits. There have been so many lawsuits filed against the government, whether it's regarding the H-1B employer-employee relationship, or whether it's about the fee hike. There are also lawsuits that are pending regarding the asylees. There are also lawsuits pending regarding DACA. There are also lawsuits that are pending about TPS cases. There is a lawsuit that they just lost about the diversity visa group. So the government has been at a loss of all these lawsuits. So they're not in a very happy situation. So my experience tells me that if you file an application and if they find anything that is missing, they can have a scope to say, I'm rejecting this application. And it's going to be discretionary, of course. And if they do that, you don't get your application back for another 3 weeks or 4 weeks, and you've lost the October 27th deadline, then you lose your scope in the line. So my opinion, it doesn't matter. You're spending so much money. Please do your medicals, attach the medical examinations and send it. I wouldn't give them a scope for rejection.
Both husband and wife on two different H-1Bs, and husband applied for I-485, included wife in the application. Can wife go to India for H-1B stamping?
Absolutely. Both of them can apply for the adjustment of status, but remember, you need an advance parole, even though you don't use it, and you can still go for a stamping, get your H1 stamping. I'm talking of the spouse, can definitely get an H1 stamping and come back. They don't have to use the advance parole, but they should be in possession of an advance parole, because otherwise the I-485 will be deemed abandoned.
Okay. I'm on EB2 with October 2011 date. Today, if I believe that EB2 date of filing will advance in next 2 months and I'll get EAD, later if EB3 final action becomes current before EB2 final action, can I downgrade then?
If they're accepting the filing dates at that point in time, we don't know if they will. This is, as I said, one chance that we've seen. Now, will they continue for each bulletin to accept? The bulletin may give that. The bulletin is published by the Department of State, but it is the USCIS who makes the decision whether they're going with the filing dates, date of filing, or with the final action dates. And if they determine the next bulletin in November, December, Jan, Feb, March of 2021, they're only going with the final action dates, you may not have the opportunity to file it. So you'll have to wait whenever they are willing to accept the dates of filing versus the final action.
Can you have both H4 EAD and GC EAD and not use GC EAD?
Absolutely, you can. Nothing is preventing you.
Okay. We know that we have to stay with current company for 180 days after 485 is filed. Also, as I am downgrading to EB3, do I have to wait 180 days after the new I-140 EB3 is approved to move out of the current company? Can my employer revoke my downgraded I-140 if I leave the company after completing 180 days after 485? But if I have not completed 180 days after the I-140 is approved?
Well, that's a big confusing question. All I can say is from what I could understand, if if they file an EB2 to EB3 downgrading through a current employer, but then the employer determines some point later they don't want to go through with the amended slash new I-140 for the downgrading, it's up to the employer. They can always do that. And if they do that, then your 485 will also be denied because you don't have the underlying 140 that is approved and or pending. If they do that, yes, you would lose your money, you'd lose your chance to be in the line. What happens? You will have to file another perm I-140 through another employer and recapture that date, because even if they revoke or withdraw the I-140, you had a previous I-140 that was approved as an EB2. You can recapture that date and then process it through your new employer. Yeah, the employer always has the ability to always withdraw I-140s.
After downgrade, if EB2 becomes current and we upgrade, is that possible?
As I
I
mentioned,
think you already, yeah.
I'm repetitive, but as long as you don't use the EAD and the advanced parole, you've not used the benefits under EB3, your EB2 has always been intact even after your downgrade. So you can go back to that since you've not used the benefits, and you can file an application for adjustment of status under that. But I would definitely have to withdraw this EB3 filing because you can't definitely have two applications pending.
I'm on H1B planning to file my extension in premium. Will the new rule support premium processing of H4 along with H1? Does it need a separate premium fee? How it impacts the biometrics? New premium timelines for H1 is 30 days or 45 days?
I haven't gotten the entire information, whether it's 30 or 45 days. First of all, very recently they came up and clarified that the premium processing, which used to be 15 calendar days, is now 15 business days, first of all. So having said that, with the HR 8337, I believe they are mentioning either it's going to be 30 days or 45. As I said, I don't have that info in front of me. If I do get my hands on it, I will bring it up to y'all in the next few minutes, but I don't have it in front of me.
I'm on H1B planning to file my extension in, I think we just finished that one. Okay. Can I travel to India with H1B while I-485 is pending, not receive the EAD?
You don't need an EAD, but you need an advance parole. And you don't use the advance parole, you can always use the your H1B stamping to come back, but you don't need an EAD for travel, just the advance parole.
Can USCIS return the application even after issuing a receipt notice?
No, they don't return it after issuing you a receipt. They can issue an RFE for you if you're missing documents. Could be for the 485J, or if you've not submitted the I-944s, or if you've not submitted birth certificates or marriage certificates. They can always issue an RFE, which I think is a common thing for people in the H1 industry. You all see this day in and day out. So no, they don't return packages. If they are returning, they return it with the check as a rejection.
Okay. When will N400 applicants get appointment for biometrics? The delay seems too long.
I understand, but you do have to understand too, we are not in a normal lifestyle. We're all living under COVID. So due to COVID, the biometrics or the application service centers were all shut down until very recently. I believe they've opened up on August the 27th. And they are not having as many applicants as they used to. You know, in a day, they would have at least 400 to 500 applicants going and doing their biometrics. But now, due to COVID, they're restricting the number of people coming in for the safety of the applicant and the safety of their employees. I am sure you will understand that, because of this, there are delays. We do understand it is an extended period, but however, no one anticipated COVID will continue to remain for this long. So one has to be patient. Just wait for it. I am seeing the biometrics in my office. My clients have started receiving the biometrics for all those who were canceled way back in March, April. We are just beginning to see, but it is not huge numbers. They're trickling in very, very slowly.
Okay. My L1B individual visa extension is in progress, but my employer asked me to go back to India due to project unavailability. I have not filed H1B this year. Is there any option to file H1B now so I can continue to stay in US to find another job?
No, sir, ma'am, you cannot file an H1 now. The H1 cap season is over. They had the registrations back in March, and whoever registered had one round of filings. The filing date, I believe, was June 30th, 2020, and the second registration picked up only a couple of months ago or a month ago. And no, if you've not filed it under the cap season, you're not eligible to file an H1 change of status now. Now, I don't know why your employer is asking you to go back. That is a personal decision on their part. They can still keep you on the payroll until such time they can get you a project, but that is going to be their decision. Now, the only thing that you can do if you don't want to go back and your employer is not willing to cooperate and you cannot travel immediately to India or wherever you're from due to COVID and your kids are in school or you're unable to get flights, is you can convert your L1B to a B2 visa and remain here until such time that you could remain legally, and then you can go back, and if the L1B extension is granted, you'll have to go to the consulate to get a stamping to come back into the country. So that is the only option you can do, is to convert that L1B to a B2. And in the recent past, we've done this. My firm has done this for a lot of applicants on L1A, L1B, H1s, those who could not find an employer in the 60-day grace period. Both L1s and H1s had the 60-day grace period. And a lot of people, due to COVID and unemployment situation, could not find jobs. So we were able to successfully get them a B2 visa right here. We could do a change of status, and that gave them a little scope to think what they want to do and work with their families, children, including a lot of people who had to make some avenues for the sale of their house or give a power of attorney to somebody for their car payments, house payments. There's a lot of things to do, for people before they get out of the country. So this is one scope you can avail of if you don't want to, if your employer is not working with you to do a change of extension of status on your L1B. I hope that answers. And if you need help, please reach out to my firm. And I would appreciate if one of the executive board members will put my number and email in the chat. If anybody wants it, you can get it out of there.
If my job requires frequent travel and working from India and from USA, when my I-485 is pending, can I stay in India office for a year continuously if I have valid H1B visa, which is valid for 3 years with my employer?
You can, but if your 485 is pending, again, I'm repetitiously telling you this, you need to make sure you have an advance parole, because otherwise your 485 would be considered abandoned. You can always go and work from there and come back. Now, if you will need a stamping to come back, and if you already have a stamping, you can come back on the H1B stamping. But the only thing, by applying for the advance parole, it protects your 485 so that it is not abandoned. Now, if your priority dates, the final action date is current, you can also avail of the second opportunity, which is filing through a consular processing to get your green card. You can do that. However, please keep in mind that President Trump had issued a proclamation or a ban of employment-based green cards at the consulates until December 31st, 2020. Now, if he extends that, then you may not be eligible to get a consular processing green card. So in that case, I would definitely advise you to file the 485, you file the advance parole. Even if you don't use it, you can always get a stamping to come back into the country.
Okay. If a situation arises that after I-140 is approved, the employee has to go to India, what are the disadvantages of consular processing of the employment-based green card?
Which I just mentioned it. Employment-based green cards have a ban due to the proclamation President Trump announced, I believe, on June 22nd, 2020, wherein he said there would be a ban until December 31st. Now, if he extends this executive order / proclamation, we don't know how long that's going to be, and you may not be able to get your green card.
My prior company's EB3 priority date is December 2014. My current company filed my EB2 I-140 last month and it just got approved. As my perm is still unexpired, do I have a fair chance to file I-140 in EB3 and 485 concurrently?
Yes, you can. You can file it. You have a priority date of December 2014 with your previous employer, and I'm not sure if that was an EB2 or EB3, doesn't matter. Your previous employer, if he filed it under EB2, can downgrade it and do an adjustment of status, or your current employer, who I assume has recaptured the December 2014 date, and file the under EB2, can downgrade it to an EB3 and file for your adjustment of status.
I have I-140 approved under EB1C and my filing date is current, but my employer is asking me to move to another country for business reasons and he will do the consular processing later. What's your suggestion? Should I insist to get done and leave once EAD or AP is done? They need me for business in other country.
I definitely would insist on filing the I-485 since it is current. And, EB1 also, as I mentioned earlier, has been going back and forth. There's been retrogressions and, that category has also been a little inundated with a lot of applications for people from India. So if your EB1C category, EB1 is current, I would definitely insist with the employer to file the 485. And of course, the 485 is your application. You can file it. All you need is the employer to give you a 485J, and then you can file for the adjustment of status. And believe me or not, I've done this with several employees from Deloitte, and yesterday we are still working for an employee with E&Y where the employer was not being extremely cooperative in doing this. And so we have ways and means of helping out such clients, and I'll be glad if you want to reach out to me and we can try and help you with filing the adjustment of status, because that is your adjustment of status. You don't have to deal with the employer other than the 485J. But there are ways and means around that as well. So if you want to reach out to me, I'll be glad. Please, my website is mantralaw.com. Send me an email and I'll be glad to respond to you.
Uma garu, we have 3 more minutes, but we have quite a few questions. I don't know how the Zoom will act, like whether it will disconnect or it will continue. But if in the case if it disconnects, do you want them to send an email with their questions?
Yeah, absolutely. Please ask them to send an email. And I don't know in this 2 minutes if I can quickly request if TCA or Sneha Hastam believes this is a very important topic for our community, if we can do one more webinar I know it's a lot of efforts on everyone's part, but if you all want to, I'll be glad to do another webinar.
Uma Garu, glad you mentioned that. I was just about to ask if we can do a follow-on session because of the participation in this call and looking at the number of questions. I think it calls for a follow-up call. If you're okay with it, we would like to set up a follow-up.
Absolutely, absolutely, Geeta. You have my consent. Absolutely.
Thank you so much, Uma Garu. And for everybody on the call, probably we might not, of course, we went an hour beyond the time that we mentioned in the flyer. And a follow-on session will get all the questions answered. Uma Garu, did you want to add anything to wind up the call?
Sure. Very, very quickly, once again, a big thanks to Sneha Hastam and to TCA for the great job you all do for the community. And we will do the follow-up through these organizations. And everybody hang in there and don't lose your faith. Don't lose your cool on this, and don't jump your gun by just going by blogs or WhatsApp messages, because I see a lot of people making this mistake. Please don't do that. Please consult an attorney before you take any steps so that you don't regret what you've done, because life is not a copy paste, whether it comes to immigration or anything else. There is no copy paste in life.
Thank you, Uma Garu. And thank you for participating in the session and making the, Uma Garu, thank you for making the session happen. Indra Garu, would you like to add something to the call before the call drops off?
Yeah, only thing. Yeah, thanks a lot, Uma Garu, for doing this to the community. We definitely see your passion and your knowledge on this immigration aspects. Definitely helpful in this critical times when everybody has so many questions. We have seen it for like past 2 hours. A lot of questions have been answered, and thanks a lot. Thank you so much. And
my pleasure. And we'll look forward to the updated session or a follow-up session from TCA and Sneha Hastam. Thank you, Devi Garu. Thank you, Indira, Sirisha, Geeta, everybody, each and everyone. If I've not taken somebody's names, my apologies to everyone. And everyone who joined, I hope you got some directive from me. And if there's further remaining questions, please send it to TCA or to Sneha Hastam. They will direct it to me and we'll follow it up in the next session.
Thank you so much, Uma Garu. This YouTube video will be posted on TCA Facebook page and even Sneha Hastam's. I hope Indra Garu can attest to that.
Sure, Andy. Yeah.
And we'll set up the follow-up session soon and we'll pass on the flyer. Please
Absolutely.
look forward to the follow-on session.
Absolutely. And remember, TCA owes me a dinner.
Absolutely.
Absolutely.
It's on me.
Yeah.
Thank you very much.
you,
Good
Uma
night.
Garu.
Yeah,
Thank
thank
you
you
and
so
good
much,
night.
Uma Garu. Good night.
You're
Good
welcome.
night, everybody.
Good night.
Thank you
Thank
all.
you all for joining.
Bye.
Bye.